between the statement of the person. We already know that whenever the statement is given, there is the three stages on which the statement must be recorded. First is the chief examination of the witness. Second is the cross examination of the witness, and if required and it's correct in the eyes of the court, then re-examination. If it is required in the opinion of court, then re-examination may also be taken. So he was given the statement in the chief examination, and when he was cross-examined, there was some discrepancies in the statement, a minor discrepancies, and the opposition want to use this discrepancy as we do not have to rely on such a statement. We do not have to take a statement because there is a discrepancy in two statements. One is given in the chief examination and another one is given in the cross examination. So there is the difference in the statement and there is the minor discrepancies in the statement. That is why we do not have to use such a statement. That statement is worthless. Honorable Court in so many cases says that it is possible that the memories was lost on some points, but we have to see at the time of taking the statement that such statement is on the main pinpoint is correct or not. Some discrepancies was like that he was weared a blue shirt. He was weared the blue shirt, and this type of a statement was recorded in the chief examination. But in the cross examination, he said that I was weared the deep blue t-shirt, and chief examination he said the blue t-shirt, and now he said the deep blue. Now opposition want to use in the argument that his statement is not correct because he was given two different colors of the t-shirt in his statement. This is the minor discrepancy. We cannot dishandle the whole statement as there was a discrepancy in the statement. Suppose he says when I was reached to the on spot, there was 2 or 3 persons was there already, and in the cross examination he said that when I was reached there, 2 or 3 persons was arriving on that point behind me. At one place he said that 2 or 3 persons was there when I was reached there, and in the cross examination he said that 2 or 3 persons were arriving behind me, and simultaneously they was reached to the on spot with me. There was the minor discrepancies. The thing is that all the 3 persons, 2 or 3 persons was there or not at the time of a spot, at the time when the witness was reached to the spot. Whether they was arrived with me or they was arrived there, they was presented 2 or 3 seconds ago, or they was behind me. After all, we can say that all the 2 or 3 witnesses, all the 2 or 3 persons was there at the time at the time when the witness was reached to the spot. So these are the minor discrepancies. We do not have to take an action we do not have to inactivate the statement because there was a discrepancies. So we have to see that the minor discrepancy do not have any value, but if there is the discrepancy in the major statement, then it has to be seen, it has to be taken. Now trap witness, trap, T-R-A-P. Trap witness means strata of the witness. Strata of the witness. If the witness belongs to the poor strata, then his
Status of the
strata, like from the poor strata. He was not a rich person, he was a rickshaw driver, or he was the daily worker, he was the monk. Monk is not from the poor strata, they are the very rich strata due to knowledge. But someone want to calculate that they are not from the normal strata, that is why his statement must not be taken here. What is the value? Somebody says that what is the value of that person? He do not have a value in the society. That is why his statement is not relevant. Honorable Court in such matter said that the strata do not have a value. The value is of the statement, what he seen, what the knowledge he have. So we have to see here that what is his knowledge and how he can help to the court. Only one thing we have to see at the time of recording the evidence, that his mental status is right or not. If his mental status is not correct and he is not able to understand the questions, he do not having understand, he can't understand the manners, he can't understand the nature of the act, nature of the questions, then his statement must not be taken here. Otherwise, from which faction he belongs doesn't matter, from which strata he came doesn't matter, and what is the age of the statement giver is also do not have any value. The child who can understood the nature and consequences of the statement and nature and consequences of the questions, the statement of that person is correct. Any child whose age is 7 or 8 years,
if he is of 5 years and he can give this statement.
This is the duty of the court to understood that he is able to understand the matter or not. Means his understanding power is sufficient or not. This is the duty of the court.
अगर सपोज कोई 5 ईयर का चाइल्ड है,
हाँ,
उसके फादर या मदर कोई आके डेथ करता है और उस बच्चे ने उसको देखा हुआ है, फिर उसका स्टेटमेंट बाद में एज अ एविडेंस यूज होता है प्रोसिक्यूशन के टाइम पे, तो उसका स्टेटमेंट रेलेवेंट होगा उस चाइल्ड का?
बिल्कुल रेलेवेंट तो है ही। मैं ये कह रहा हूँ कि सिर्फ अपने को ये नहीं देखना कि उसकी एज क्या है। वी हैव टू सी देयर दैट ही इज अंडरस्टैंडिंग द नेचर और नॉट। वो जो बोल रहा है उसको समझता है कि वो क्या बोल रहा है। इफ ही इज नॉट एबल टू अंडरस्टैंड हिज लैंग्वेज, हिज ओन स्टेटमेंट, व्हाट ही इज सेइंग, देन वी डू नॉट हैव टू टेक एन स्टेटमेंट। If he is able to understand and the whole circumstantial evidence is supported by his statement, then there is not any cause to not to take his statement as an evidence. So for minor also, now relative or interested witness, relative or interested witness, the statement of the relative or interested witness must be taken or not. They said that if his brother was died or murdered and he was present on the spot, he was tried to save it, save his brother. Now the statement of the brother given before the court against the murderer or accused, now accused said that he is the real brother of the victim, that is why it is but natural that he will give the statement against me. Honorable court said that this is the natural witness. If his brother was presented there, his relative was presented there, or any close relative was presented there at the time of his murder, at the time of the injury, at the time of accident, then his statement is more natural than the statement of another's. because he was hardly related with the incident. And if he was hardly related with the incident, then the narration of such incident may be or must be but natural by the brother of the victim or deceased. So there is not any cause not to take an evidence, not to take a statement of the brother who was present at the time of the crime. So if somebody said that they are the relative, that is why he will give the statement in the favor, or he will give a statement against me itself. These are not true, because Honorable Court in so many cases says that if he was only one person who was present at the time of crime, then his statement is but natural. His statement is more natural than the statement of another's, because another person was seen the incident, but they do not had the interest in the incident. That is why they seen and gone away. But the relative or more relative of the deceased or relative of the victim was hardly connected with the incident. That is why he can explain more expeditiously, or he can explain in more factual situations what was the step and what was the stages from where the incident was happened. That is why we can't say the statement of the relative or interested witness must not be taken. It's depend on the circumstances that his statement is supported the circumstantial evidence or not. If his statement is not supported to the circumstantial evidences, then why we have to take? Even if the victim himself given a statement and his statement is not supported by the circumstantial evidences, his statement is not supported by the injury caused to him, his statement is not supported to the medical examination report, then why we have to take a statement of the victim also? Because we are using the Evidence Act to find out the truth, and truth from anyone included the victim also. In case of child witness, there is the case of Panchi versus State of Uttar Pradesh. Panchi versus State of Uttar Pradesh. They said that there is not any law. Write down the judgment. They said that it's a judgment of the Honorable Supreme Court. Honorable Supreme Court said that there is not any law that if a witness is a child, his statement shall be rejected. His statement shall be rejected even if it is found reliable. Even if it is found reliable. So, it is clear from this judgment of the Honorable Supreme Court that the statement of the minor, if it is really relevant and it is reliable, then we have to take it. Now, the question is testimony of the police officer. Testimony means a statement of the police officer. Honorable that is the statement. Testimony word is used like on oath, the statement on oath.
So then it will be reliable.
Yeah, Honorable Supreme Court decided in the case of state of Assam.
And statement given on oath.
State of Assam versus state of Assam versus महिम बरकत की, बरकत, हाँ, बरकत की. इट इज ए जजमेंट ऑफ 1978, वो 1987 by the Honorable Supreme Court. Honorable Supreme Court what decided in this case that the testimony of a police officer, the testimony of the police officer